This is Zachary Webster. He's a former deputy guilty of ruining more than 33 lives by planting false evidence. Webster, whose father was a well-respected law enforcement officer, began his career as a deputy in 2015 at the Liberty County Sheriff's Office. However, his employment was short-lived due to allegations of sexual misconduct. In 2016, he joined the Jackson County Sheriff's Office, where he became known for his aggressive approach to patrolling and high number of drug-related arrests. In the summer of 2018, prosecutors in Mariana started to question Webster's conduct, citing inconsistencies in his police reports and body camera footage. One particularly incriminating body cam video showed him holding a plastic baggie before conducting a search that led to a woman's arrest for methamphetamine possession. Following an internal investigation, Webster was suspended and subsequently fired from his position after the discovery of a stash of drugs and paraphernalia in the trunk of his patrol car, which appeared to be prepped for planting. In 2019, after a lengthy investigation by the Florida Department of Law Enforcement, he was arrested for his wrongdoing. His sentencing is something that people want to see, the face of the corrupt cop that took everything from innocent people.
Being here today, but did write a letter. It's a part of the record, and Mr. Emanuel. The evidence at trial demonstrated that the defendant planted methamphetamine or paraphernalia in each of these victims' cars under the guise of performing a lawful roadside search of their cars. He then falsified arrest reports and submitted them to the sheriff's office. These false records were later relied on in this very courthouse to prosecute these innocent victims for crimes they did not commit. And at the time of his suspension from the sheriff's office, he had a stash of more methamphetamine and more paraphernalia hidden in his patrol car for that very use. Now, Judge, the defendant's criminal conduct represents an egregious breach of the public trust. The state's first exhibit in this case was his identification card from the Jackson County Sheriff's Office. And I read an opening statement and in the record at trial, the oath that he swore to hold that badge and that ID card. And in democratic free societies, people voluntarily grant their government awesome powers that they deem necessary for public safety and protection.
Police officers like Zachary are examples of why people lose trust in the police department and those government facilities that are supposed to protect and serve the people.
As follows as to the counts charged and the information. Count 1, guilty of racketeering as charged. Count 10, guilty of official misconduct related to Stephen Van as charged. Count 11, not guilty.
Zachary Webster is currently serving a 12-and-a-half-year prison sentence for falsely accusing innocent drivers of possessing meth and has reached a settlement with 33 individuals whose lives were adversely impacted by his actions. The settlement resolves the federal lawsuits filed by the plaintiffs who accused Webster and his former employer, the Jackson County Sheriff's Office, of violating their civil rights.
We've got a fully executed plea document that provided in pertinent part that he was to serve 75 days in jail, and he's going into jail today.
This is Sheriff Todd Pate, who was caught not once but twice driving under the influence, and this time injuring another driver. On March 8, 2019, Sheriff Pate, aged 51, was arrested and charged with his second DUI after causing a crash that resulted in injury to another driver. An investigation uncovered that Pate had been stopped by an officer and released just before his arrest. The case was assigned to Special Judge Janet Crocker and Special Prosecutor Blake Chambers, and Pate was charged with 9 counts, including first-degree assault, operating a motor vehicle under the influence, 4 counts of wanton endangerment, first and third-degree criminal mischief, and leaving the scene of an accident. The citizens of Breckinridge County, Kentucky, started a petition and demanded the immediate resignation or removal of Sheriff Todd Pate from his office without any further compensation due to his numerous offenses. This is what they had to say. Sheriff Pate has repeatedly broken the law by driving under the influence of alcohol, endangering the lives of the public and himself, and tampering with evidence. His actions have breached the trust and confidence of the public, and he's neglected his duty and responsibility as a law enforcement officer. Moreover, Sheriff Pate has exhibited poor judgment, lack of self-discipline and control, making him unfit to hold others accountable for their actions. He's violated his oath of office and does not reflect the values of our community, nor does he have the trust and respect of the people he serves. While we wish Sheriff Pate well in his future endeavors, we firmly believe that his immediate removal from the Sheriff's Department of Breckinridge County, Kentucky is necessary for the safety and well-being of our community. Before the hearing, Pate expressed his willingness to accept a plea deal that would entail 75 days of imprisonment with credit for time served. But this is where it gets interesting.
Is that your phone, Mr. Page?
Yes, it is.
You need to put it away.
Okay. I was just had
You need to
a.
put it away.
Okay.
It was already a bumpy start to Todd Pate's court hearing.
Can I make somewhat of a statement? That's
That is a yes or no.
The hearing started on rocky feet for Todd, but that's not all.
I did that March 8th when I drank and drove. Thank God I didn't kill anybody. But I want this court to know, I want the people to know, and I want the public to know that Todd Pate holds himself responsible for everything that he did. But it's hard for me to lay down and plead to felony charges that don't apply.
So I think we are back, Mr. Pate, and probably should have stayed in the place where we started. Again, I wanted to give you an opportunity to have further discussions with your attorney. But I
And I'm
think
sorry, ma'am, for
no,
doing
you don't
this.
have.
I'm sorry for.
What I need to, I think we're back to where we were before. Is it your intention today to enter this guilty plea? And I think we're at a yes or no place at that point.
Can I say one more thing? I think everybody in this room wants this over with. And if I could address Blake, I hope you learn from this case I'm not mad at you. I'm not in any way upset with you.
Mr. Pate,
Not that it
we
matters.
have reached that point now.
Okay.
This is either a yes or no. Are you going to enter your plea or not?
I guess everybody thinks it's funny.
Certainly not the people who I think are here with you today, Mr.
No, they don't. I've broken everybody's heart. But it's hard for me when I see Mr. Chambers sitting over there smiling. Let me just plea and get it over with for everybody. Plead to something that I absolutely do not feel good about, but I don't want you to try to send me to the penitentiary for years and years. If you can sleep with it, I can sleep with it.
Okay.
And this is probably
I think
unusual,
we're done.
but
At
let's
this
do
point in
it.
time, I think we're done. And so let me tell you where I think we are today, is that we have executed plea documents.
Todd is a former sheriff acting egotistic and almighty, but he's about to find out how the world looks different from the other side.
I've already ruled at this point in time. We're done at this point in time, other than setting this for further hearing as to whether or not the Commonwealth can enforce this plea, whether or not the Commonwealth is going to choose to withdraw its plea offer, whether or not the Commonwealth can withdraw its plea, and then whether or not Mr. Pate can withdraw his plea. But at this point, we've got a fully executed plea document that provided in pertinent part that he was to serve 75 days in jail, and he's going into jail today.
He ended up serving only 29 days and paid an $800 fine.
Strictest sentencing and sanctions. Your Honor, please do not send me to prison. I have roamed, but I'm not ruined. I still have a lot of good left in me.
This is Sheriff Charlie Reeder, who got caught being a thief and tampering with evidence. The charges against Reeder stem from allegations that he stole thousands of dollars of confiscated evidence in other cases. Reeder claimed that he took the money from drug dealers to help the community and plant memorial trees. He also attempted to defend himself by saying he'd not used the money for personal gain, despite prosecutors' claims that he made suspicious expenditures in Las Vegas. During his sentencing, Reeder's defense attorney, James Bulger, said that his client is a decent human being who's done what he could to help the citizens of the country. However, Judge Patricia Cosgrove emphasized that Reeder's actions damaged the trust that citizens had in law enforcement and made a mockery of the sacrifices that law enforcement officers make every day. Reeder's sentencing memorandum outlined other elected county sheriffs in Ohio who'd also committed similar offenses in the past, including Fairfield County Sheriff Gary DeMastri, Athens County Sheriff Pat Kelly, Sandusky County Sheriff Kyle Overmeyer, Mahoning County Sheriff Phil Chance, and Allen County Sheriff Samuel Krish. Reeder claimed that the stress of investigating the Roden family massacre in 2016 led him to start gambling, which eventually caused his mental health to deteriorate. Judge Cosgrove acknowledged that law enforcement officers see horrible things, including multiple deaths and torture of old people, but emphasized that Reeder could have sought free counseling at any time for his conduct, but failed to do so.
Which you were not reimbursed until later. You see where the state believes that some of this is due to gambling. I mean, you're talking like over or almost $6,000 in a couple of months that you lost. are expended on gambling.
And at that point, we were making almost $11,000 a month. And that
Okay.
again was from my checking account, where it should show my direct deposits, my wife directs deposits, and that it came from our debit cards where I retrieved that money.
Charlie's gambling addiction went so far that he gambled stolen money from drug dealers.
As a sheriff of Ohio, I shed, excuse me, I shed bad light on the office of sheriff. I can only ask that my staff, their families, the community, and my family who is here today will forgive me for the undue stress I caused them. For this, I am terribly sorry. I stood in this court on September 24th and pled guilty to the charges against me, to accept responsibility for my conduct. That day, within minutes, everything that I'd worked for professionally and honorably for 25 years was stripped to me, with nobody to blame but myself. My staff and I had united with the community and had a partnership and trust.
Former Pike County Sheriff Charles Reeder was sentenced to 6.5 years in prison, of which he'll serve 3, after pleading guilty to 5 charges, including theft in office and tampering with evidence. This is Kim Potter, a former officer who made a mistake and shot with her gun instead of a taser. Kim Potter, a former police officer who fatally shot Daunte Wright, a black motorist, during a traffic stop, was sentenced to 22.5 years in prison on Friday, December 31st, 2021. Potter, who had served as a police officer for 26 years, claimed that she mistakenly fired her gun instead of her taser during the incident in April 2021. She was found guilty of second-degree manslaughter and first-degree manslaughter by a jury in December 2021. Potter tearfully apologized to Wright's family before the sentencing, but the family expressed their disappointment, saying that Potter's tears trumped justice. The judge's comments at the sentencing showed a clear absence of compassion for the victim, according to the family's attorney. Potter's trial took place against the backdrop of a national conversation around policing and systemic racism in the United States, sparked by the killing of George Floyd by Minneapolis police officer Derek Chauvin in May 2020. Floyd's death set off months of protests across the country, demonstrators calling for police reform and an end to the disproportionate killing of black people by law enforcement. Potter's conviction in the killing of Wright was seen as a rare instance of accountability for a police officer involved in the death of a black person. According to Mapping Police Violence, a research group that tracks police killings in the United States, police officers are rarely charged and even more rarely convicted for their role in such deaths. Potter's case also highlighted the issue of police training and the use of force. During her trial, experts testified that the former officer had been inadequately trained and that she had made a series of errors that led to Wright's death. Potter testified in her own defense, saying that she had intended to use her taser on Wright but mistakenly grabbed her gun instead. Prosecutors argued that Potter had acted recklessly and that she should have been aware of the difference in weight and feel between a gun and a taser.
Would Miss Potter please rise? I'm now going to read your verdicts as it will appear in the permanent court records of Hennepin County. In the matter of State of Minnesota versus Kimberly Potter, court file number 27CR217490, we, the jury, on the charge of manslaughter in the first degree while committing a misdemeanor on or about April 11, 2021, in Hennepin County, State of Minnesota, find the defendant guilty. And the verdict was agreed to at the hour of 11:40 a.m. and signed by the jury person on 12/23/21. The verdict on count 2 is we, the jury, on the charge of manslaughter in the second degree, culpable negligence on or about April 11, 2021, in Hennepin County, state of Minnesota, find the defendant guilty. And that verdict was agreed to at 10:30 a.m. on 12/21/21. Members of the jury, is this your true and correct verdict? So say you one, and so say you all.
Yes.
Okay, you may be seated.
This is Derek Chauvin, a former officer who took the life of George Floyd for a counterfeit $20 bill. George Floyd, a black man, died on May 25, 2020 after Derek Chauvin, who is white, used his knee to pin Floyd's neck to the ground for over 9 minutes. Video of the incident went viral, sparking protests worldwide against police brutality and racism. The judge's decision highlighted that no one, not even law enforcement officials, are above the law and must be held accountable for their actions. Chauvin was sentenced to 22.5 years in prison after being found guilty of second-degree murder, third-degree murder, and second-degree manslaughter. He also pled guilty to a federal civil rights charge and was sentenced to 21 years in federal prison, which he's serving concurrently with his state sentence. Chauvin's attorney argued that the trial should have been moved and the jury sequestered due to the extensive pretrial publicity and unprecedented security measures, including the presence of the National Guard.
As sentenced for count 1, the court commits you to the custody of the Commissioner of Corrections for a period of 270 months. That's 270. That is a 10-year addition to the presumptive sentence of 150 months. This is based on your abuse of a position of trust and authority, and also the particular cruelty shown to George Floyd. You are granted credit for 199 days already served. Pay the mandatory surcharge of $78 to be paid from prison wages. You're prohibited from possessing firearms, ammunition, or explosives for the remainder of your life. Provide a DNA sample as required by law. Register as a predatory offender as required by law. And then you will receive a copy of the order and also the attached memorandum explaining the court's analysis. Anything further from the state?
If this needs to be said, we just...
Chauvin addressed the crowd, acknowledging the politically charged environment and wishing Floyd's children the best in their life, but did not apologize. His lawyer requested a sentence of 20 years, while the judge ultimately sentenced him to 22.5 years.